but with the parliamentary approval of the offices of the third and fourth defendants, is consultation with the Council of State still needed to perfect these appointments? If the answer to the question is in the negative, as it certainly is, what then is left in the plaintiff's action worthy of adjudication? Which provision in the Constitution and Act 463 require the President to consult the Council of State in nominating people for ministerial positions? Indeed, if the plaintiff had not hurriedly rushed to issue this writ, he would have realized that the offices he was complaining of were not contemplated by the President to be offices under Act 463, and consequently did not require consultation with the Council of State. The plaintiff thought the offices were those under Section 4.1 of Act 463, but events thereafter have shown that they are not. In respect of the fifth defendant, there is similarly nothing to show that it is an office under Act 463. I think it is important, quote, to appreciate that it is not every appointment by the President that requires the consent of a Council of State or Parliament. Just to give a brief background to this case. At the time the announcements were made, there was no Council of State. I believe that was why my mate and colleague rushed to issue the writ. But subsequently, President Kufuor submitted the names of Jacob Echebi Lamte and Ms. Ohini to Parliament for vetting, and they were subsequently vetted and approved for various ministerial positions. For example, the judge continued, appointments under Section 7 of Act 463 do not need the consent nor consultation of anybody. Those are the appointments of experts or consultants. Whoever therefore alleges that a particular presidential appointment requires the consent of another body must clearly demonstrate the relevant law and regulation showing that that particular appointment indeed required that approval. Continuing further, the learned judge explained and concluded as follows. In the instant case, I'm fully satisfied that the subsequent approval by Parliament had unequivocally shown that the offices complained of were not those contemplated under Act 463, and that the said parliamentary approval had glaringly exposed the fallacy underlying plaintiff's action and rendered same pointless for adjudication. The plaintiff's action is nothing but an exercise in futility, unquote. The Pega JSC, on the other hand, held as follows. From the above provision, he quoted Section 3.1 of the Presidential Office Act and continued. From the above provision, it is patently clear that only persons who belong to the first category and are appointed under the Act can be appointed by the President to head the presidential office. What he was saying is that it's only those people appointed by the President with on the advice of the Council of State who can be asked to be Chief of Staff of that office. Therefore, the argument hardly need be made that those persons who belong to the second category and have either been seconded or transferred from the public service cannot be appointed to head the presidential office. Not even a Minister of State, not having been appointed under the Presidential Office Act, Act 463, can be appointed to head the office, page 166 of the report. My concluding remarks. Comments by the Supreme Court judges on the constitutionality of the Presidential Office Act, as appears below, indicate that the thinking of the judges at the time was clearly that there was nothing unconstitutional about the Act. Justice Ampere, JSC, who was one of the judges who were in dissent, had this to say about the Act. Quote, it cannot be said that the Presidential Office Act, 1993, Act 463 is inconsistent with the Constitution. This is what he said as an obiter. Pega JSC, who was also in dissent, had this to say about Act 463. Commenting on Section 3.1 and 4.1 of Act 463, the learned judge declared and stated as, quote, It is therefore a requirement of the Presidential Office Act, 1993, Act 463, which act certainly cannot be held to be inconsistent with any provision of the Constitution, that any appointment under the Act should be made in consultation with the Council of State. You can see this at page 166 of the report. These comments, as well as the rendition by the majority of the court in the Martin Amidou case, supra, convinces me that the thinking generally is that the Presidential Office Act 1993, Act 463, has been properly passed by Parliament and is thus consistent with the Constitution. It may therefore be a very difficult thing to undertake to declare Act 463 as unconstitutional. Maybe I would suggest lobbying and advocacy with relevant government agencies with a view to lessen and reduce the effect of the operations of Act 463 on the fortunes of the civil and local government staff in the service, and the service might be more productive. The Supreme Court of Ghana, however, is empowered by the Constitution to depart from its previous decisions. And as I have indicated, the views of Justice Ampia and Pega on the unconstitutionality, on the constitutionality of Act 463 was not the main issue before the court. These are things we will say. Mr. Urukubobe is here, and all the lawyers who are here will understand that they are obiter. They don't form part of the core decisions of the Supreme Court. So for now, I can say with all certainty that that issue, the Supreme Court has not yet been called upon to declare whether the act is constitutional or unconstitutional. But when the time comes, the court will be referred to the comments by their senior brothers who have left the court about their views on the constitutionality of the act. I will urge that any such exercise to declare the act constitutional or unconstitutional must also take into consideration the unanimous nature of the Clocksack decision that I have referred to in extenso, because the Clocksack case actually has put to bed the contention that members of the civil and local government service can undertake active party politics. It is clear that they cannot do otherwise, but what is contained in the decision of Clocksack versus Attorney General. Let me leave you with this African proverb which states thus: to go fast, go alone; to go far, go together. Together is always better. Thank you very much. I can answer any questions you may pose.
Okay, so thank you. A round of applause for Justice Jones Victor Molo Duce, retired Justice of the Supreme Court. A round of applause. You can do better than that. And you may please be seated. If you have just joined us and if you are watching us at home, this is the CTHE ANANG Quao Nathananang Quao Annual Lecture and Excellence Award 2023 happening here at Nathananang Quao Auditorium at Clocksack headquarters here in Accra. And at this juncture, we are going straight up to the opening forum. We'll have our microphones around, and we need to be very brief with our questions and the comments that we want to make. So we have one of the microphones here. Can I have someone doing this for me here so that we'll be able to move very fast? And I'll plead with you to be very brief with your questions and the comments that you want to make, and we are all here. So we have political parties present here. We have minority and majority. We have leaders of parliament. We have the civil society organizations here, and other key personalities who are also here in our midst. So I would want to see you by hand if you have something to say. It's an opening forum, so just let me see a hand, the first hand. Okay, so we have Dr. Isaac Bampo. He has something to say.
Yeah, thank you. Should I come?
Yes, sir.
I'm excited today because my Blobi has made me very happy. And he quoted an African, he said, to go fast, go alone. To go far, go together. So yeah, over to you. Well, on the subject matter, we started with the closer case. And it was very clear that the Supreme Court gave 3 standards for the establishment of an executive for governance. That's anonymity, permanence, and neutrality. Judge, my question is this. Can we say that anonymity, permanence, and neutrality as a standard can be applied to the Presidential Office Act? My second question is, you said food for thought. It could be a yes and no answer. And my question is this. The Constitution stated clearly those offices that should be under Article 71. There was no mention of presidential offices. And that is a clear departure from the Constitution. I know you said food for thought, but I think this is an issue that we have to look at, because it's very clear that presidential office holders are not supposed to be under Article 71. Thank you.
Okay, so thank you so much. I think we'll take 5 sets of questions, then we come to Justice Jones. The first one, any other? Any hand around? Okay, so can we give a microphone to Justice to?
Okay, thank you, Isaac. I think I made it quite clear in my paper that it was curious for the Act to incorporate an entrenched provision in an Act of Parliament. So for me, I find it a bit strange that the Constitution, which has made a creature known as Article 71, and an Act of Parliament has given recognition to offices created under that Act, not under the Constitution. So that is also food for thought. Then the Presidential Office Act itself, the way it is operated now, and from 1993, I believe the framers or the promoters of that act intended to introduce some political clout into the presidential office. Otherwise, there would not have been the need to create that particular legislation. In any case, the position would have been people who are found capable in other government ministries or local government services will be seconded to the president's office, and they will work. Or if the president needs some particular expert advice, the law says he can appoint experts or consultants for limited periods. But the way the act was created, maybe we may look at the personality involved at the time. They wanted to satisfy him. But as I said, since the exit of the first president of the Fourth Republic, all presidents have used the law, but nobody has been bold enough to say that enough is enough. And so maybe a powerful organization like CROSAC, together with the TUC, might champion the cause and ask for a rationale in the continuation of the broad operation of the Act, which might lead to prevent some or deny some civil and local government staff from working at the presidency. Those will be my responses to the first question by my Blobi.
Okay.
The permanence. You see, the officers appointed by the president and the Act 463, there is no way we can say they satisfy the three pillars that the Supreme Court decided. And I believe that the first permanence is not there because they go with the president. If the president loses the election today, you go. Even if the president doesn't lose the election and he doesn't want you again in that office, you lose your office. And that person who is there upon appointment by the president, maybe by the nature of his qualifications, he may be neutral. By the nature of his political orientation, he may be neutral or he may not. And so on and so forth. As for permanence, it doesn't come in at all. But the other provisions are also suspect. They are very suspect. So the key issue is to maintain the issue of civil and local government staff working at the president who can be assured of all the three qualifications as enunciated by the Supreme Court. But it's also, I believe, if parties have found it useful to operate under the law, it may be that they have found that civil servants may not satisfy some of the requirements they require, or they may not rely upon them to be neutral. I believe so. Maybe judging from the case you brought to the Supreme Court, civil servants were openly contesting for primaries, left, right, center. That was why you sought for a declaration. So civil servants need to maintain their neutrality and so on and so forth, anonymity, and therefore they will have the permanence. Thank you.
Thank you too. We have representation from some of our major political parties. We have NDC, NPP. I can see a hand here. So you mention your name and then let us know where you are coming from.
Okay. My name is Frederick Frimpong Befi.
Okay.
I'm a deputy director.
Okay.
I want to find out from the eminent lawyer, judge, that did the Constitutional Review Commission see anything wrong with this albatross of a law? And if they did, what is their recommendation for going around it? Secondly, I want to come to my level. The office of the head of civil service and the ministry, which one is superior to the other? And or is there an appointment authority for a ministry? Thank you very much.
Thank you. Okay. Can you repeat your second question again? Come again with your second question.
Office of the head of civil service and the ministry, which one is superior?
Okay. Okay, I can see a hand here. Can you go to the back for me? Back. Sir, your name and where you are coming from.
I'm Akwesi Asam. I'm coming from the Department of Federal Roads.
Okay.
I wanted to find out maybe I'm coming to a level, whether if the head of Clerks Act, or let's say the Civil Servants Association, and if the TUEC, if they find some of these provisions, for instance, today on the front page, we heard Dr. Ban talking about Article 71 having to be scrapped or something. Why haven't they taken the position also to challenge these articles or provisions, test it at the Supreme Court? What we are talking about the constitutional or the presidential office. It's been lingering for so long. Why haven't we taken the bold step to confront it frontally at the Supreme Court? Thank you.
Okay, thank you. Yes, still I want to hear from the major political parties we have here, because NDC, MPP, definitely after elections, if any of them wins, they do most of the appointments. So want to hear their voices on that. Okay, so.
Okay, my first response to whether why Act 463 was reviewed by the Constitutional Review Commission or not, as you all know, it's an act of parliament. These are laws. The Constitutional Review Commission was put in place to review the Constitution and not laws of Ghana. Laws of Ghana, we have now reached over 1,000. And so the Constitutional Review Commission dealt with revision of the 1992 Constitution and not laws of Ghana. Then his second question, head of civil service and the ministry, which is superior. I cannot find it in the Constitution, so I believe that maybe the actors can answer that question. I don't know if the office of head of civil service is a ministerial position or not. I cannot answer that question.
And then there was another question.
Yes, whether many views have been raised of late on the constitutionality or otherwise, or fairness or otherwise of Article 71. I want to take this opportunity to state once and for all that in the first place, independent constitutional bodies like the judiciary, of which I was part until June 8th this year, Electoral Commission, STRIGE, NCCE, and Auditor General, who are all beneficiaries of Article 71, we do not take ex gratia. I want to make that thing clear. We do not take ex gratia because we have permanence. We stay in office until your stated age of retirement. So, for example, I have been a judge from the High Court up to the Supreme Court. I spent a little over 21 years. And somebody can stay in the Electoral Commission for close to 20 years, 15 years, before he retires at 65, because electoral commissioners retire at 70, and the deputies at 65. So we must get that thing clear. It is the political office holders under Article 71 who, because they come for fixed periods of 4 years, take ex gratia. And I don't know the basis of that, but it's in the Constitution anyway. So that is it. I want to make that thing clear.
Okay.
So anybody can take any grievance to the Supreme Court. But as I read from the Secretary General of TUC, he raised genuine concerns. But how do you go to the Supreme Court? Because the Supreme Court is there to declare acts or provisions inconsistent with this or that. Are you going to argue that it should be scrapped or what? I don't know. He's here, so maybe he will speak for himself. But so far as I know, it is in the Constitution, and I took my time to explain. It's one of the entrenched clauses. It doesn't mean it cannot be amended. It can be amended, but the process is tedious. That is all.
Thank you. We have a rep from CPP. Sir, your name?
Parado is my name.
Okay.
From CPP. I believe we all made a mistake as the political parties in 1992 when I was a parliamentary candidate in Koliklote here, when we came out with this stolen verdict issue. So one party had its own chance and its way to do things by itself. So I believe political parties will cause the problem we are facing today. And I remember when I was so young at that time, I had a chance to meet Honorable late Nathananang Quao, and he said we should come out with clarity in everything that we do at the castle. Political parties today will not say anything about Article 71. And the main problem in this country today is about salaries, wages, whereby everybody is talking about 71 because they believe in the area or the portfolio of 71, people are making it very fat over there, whilst civil servants are really not making it as it is. I have been crying as a politician from 1992 to today that political parties will not be able to make it meaningful in this country if the labor front is taken out of it. I believe we should quickly amend the Constitution to make sure that the brains I'm even seeing in this room, as civil servants, as local government officials, should be part of the political dispensation of this country. Or else Ghana will be stagnant and will be going very slow. Very, very, very slow. The labor front should have prominence in our governance. Thank you.
Okay, thank you. A hand here. Say your name and where you're coming from.
My name is Yao Ba. I'm the Secretary General of TUC. Let me first commend my comrade here and CLOSAC for this important lecture. Someone asked a question why we have not challenged it. And the reference to what is in the daily graphic today, let me give you a background. IEA under Professor Okwe has started some series and he invited TUC to state our views. The point we were making there was that Article 71 is discriminatory. And it's obvious. All those of you on single spine, you have the lowest salary in this country. But you are all public servants. And we don't see why some political elite should fence themselves off with a constitution and leave the rest to die. And so we were calling for an amendment or complete replacement of the Constitution. And that is the only way we can get rid of Article 71 and other articles that have given so much power to one person in this country. And many of the problems we are facing is because of that. If that person called the president makes a mistake, we all suffer for it. Therefore, there is the need, and it is time for us to either amend the Constitution or replace it. That's the point we were making over there. And we are saying this because, as the Honorable Judge said, it is extremely difficult to even amend an entrenched article in the Constitution. We need to, and somebody has charges, and I like the quotation the Honorable Judge said that we want to go far, and so we have to work together. I am glad that organized labor is together on Article 71. In order that we see fairness for our members, the Constitution must be amended or changed, and that we should lead the struggle. We shouldn't leave it to people on social media. We should confront it frontally, and we will. On the other thing about why we haven't gone to Supreme Court, on this matter, as the judge said, we have to amend the Constitution, and the processes are clear. But there are other issues, and you will hear us very soon, that the TUC is going to court on a number of things. If you look at the first part of Act 651, the scope of the law limits unionization. For example, immigration officers, prison officers, the police, and so on cannot join or form a union to defend their interests. We think that is unconstitutional. And so we have already instructed our lawyer to go to Supreme Court on this matter. And you'll hear that very soon. Not only that, in the law, Act 651, there are some senior positions that are not allowed to form or join a union. They can be negotiated, and employers are abusing that. Our lawyer advises that one, we can handle it in the high courts. There's another issue, employment agencies. If you're in the public service, you may not know this. Private sector workers are really struggling. Some employment agent is employed to hire or to go through the recruitment. And after the recruitment, we think that the employer should now take over. But these private sector agencies, employment agencies, are behaving like the employers. So some workers in this country don't know who, in fact, is their employer. We had a young guy at the age of 21 whose hand got cut completely during work. And we were struggling to know who is the employer. The agent says, I am not the employer. The employer says the agent is the employer. Finally, we managed to get some compensation for him. But a 21-year-old has lost his entire hand. So we are going to, that again, the lawyer says we can challenge that in the High Court. So the comrade who asked that question, in the next few days ahead, you'll hear about it. Thank you very much.
Thank you. We have a hand here.
Thank you very much for the opportunity. Dr. Agreda, the acting head of the Civil Service. My deputy director wanted to know the relationship between the OACS and the ministry. Well, we wanted to find out what ministry or which ministry. But of course, let's assume that he's talking about any ministry for that matter. Okay. I always argue that if you hide the questions from the students, they will hide the answers from you. So let me thank Justice for that elaborate presentation, very elucidating, throwing light on a number of issues. What it means is that participation in the crafting of laws, participation in the constitution of any group that will sit around a table is very important. If you are absent, you will live under whatever provisions, whatever laws that will come out, processes and so on. But on the issue of the Constitution, Doc, as you rightly indicated, because I was the Chief Director of the Ministry of Parliamentary Affairs, we were also looking at a constitutional review, and Majority Leader's position, who was my minister, his position was that the Constitution must undergo a thorough, holistic, root and branch review. That's what he thinks. And so we have done a lot of consultations with elders of this country, former presidents among others, some justices of the Supreme Court among others. And in the process, of course, the law faculties and so on, in the process we have had to put in place a consultative committee of some sort. About 11 institutions, with the Audit Service, the National Media Commission, the Judicial Service. In fact, we even have a Supreme Court judge on that committee, and they have submitted their preliminary reports, based on the consultations that they have done. And it points out that there are a number of inconsistencies, irreconcilable provisions, a lot of gray areas that we need to look at. But constitutions are also living documents. There's a reason from time to time we touch base with the original document and see whether we are living by the intent of the framers. And the justice was talking about the original intent. If you don't look at the intent, you may make mistakes. So you go into the spirit to really look at what it is that the framers actually envisioned. So that is what the ministry is doing. And because I have left, of course, I've left that in good hands, and they are working. They have a draft in place and so on. A number of areas, even the hybrid system we're operating, that majority of our ministers from Parliament, Article 78, will think that ab initio, it makes Parliament subservient to the other arms of government. It makes Parliament extremely weak because they live under, an overbearing, overmighty executive for that matter. The constitution of, let's say, the Electoral Commission and the appointment processes, the minister thinks that it has to be much more consultative. And if you are submitting or subjecting whoever is appointed to, let's say, to test majority approval of Parliament, then appointing authority will be much more consultative because you don't want to be disgraced in Parliament. So you send a candidate that is likable and likely to pass the test among others. Then, of course, people have talked about the numbers, the ceiling in the Supreme Court, for instance, and the numbers. The issue is whether indeed, the appeals will even end at the High Court or Appeals Court. And we got to look at the caseload, for instance. In the U.S., very few cases go to the Supreme Court. In the U.S. Supreme Court, they only attempt to address just 5% of all cases that come to them. So we can fix it at 9, and they will be comfortable. 9 members, we call them the 9. And they will be comfortable because the cases are few, and they can decide on those specific. And a number of areas we have looked at. Some of them have suggested that We should either go presidential or parliamentary, even though in most African countries they go for presidential, which is also susceptible to corruption because power is concentrated in one person, and therefore you need to deal with it. Some have said that why don't we go parliamentary, etc. But this is a hybrid system. I call it a marriage of convenience that we have crafted for us. It has worked well, but is it that it's going to work, in the future? We need to look at. But let's come back to what my deputy director said. Our governing framework is the Civil Service Act. Of course, we take our original Article 190, which lists the public services, including the civil service. So the civil service is part of the public service, an integral part of the public service. But the Act, our Enabling Act, which is Act what? 327, the PNDC law, 1993, establishes the structures. You go through it, the structure is there. And among others, it establishes the office of the head of the civil service, which is supposed to be the central management agency of the service, responsible for standards, responsible for the entire civil service, setting standards, any laws or policies and programs that has to do with, or that will have to do with enhancing the public realm, the public policy, and so on and so forth. So they are largely in charge of any government policy that has a bearing, or which the civil service will be in charge, and so on and so forth. In terms of efficiency in the delivery of service, among others. So call it the headquarters of the civil service. So I don't know. So if it's the headquarters of the civil service, then you want to compare the headquarters of the service to one of the federating units. So a ministry, to all intents and purposes, will be just a federating, one of the subset of the entire set. I hope you understand. So ab initio, that comparison would not have to be raised at all, but it has to exist because the office of the head of civil service will be in charge of efficiency, the service delivery, advise government on policies and programs with one object: assisting the government in the formulation and implementation of public policies and programs. That's said. Is that right? So thank you very much for.
Thank you. We've had CPP. So currently we have NPP, a rep from NPP. Time is fast spent, so we want to do NPP. Okay.
Well, my name is Rekub Ruby. I am MPP, but I'm not speaking for MPP. I'm sure the MPP person may speak. Thank you very much, my Lord. You really have distinguished yourself once again. And I love, participating in your lectures. Anytime I sit in, I learn and carry something away. From the Labor Ministry, so I'll talk about the 651, Act 651, which Doc just said. That law was passed in 2003. And 20 years down the line, you know that the world of work has really changed. So what we anticipated at that time, when the law was passed, because now we have, even post-COVID, when COVID came, you saw how the world of work became. People will sit at home. There may be sections of the law that would even prohibit you from staying home. Now, the reality is that you can't even go to the office sometimes, and you have to. So it is one thing that is receiving attention at the Labor Ministry. Through our tripartite, we have met, extensive consultations are being done, and some of these provisions we are saying, whether or not to join union. And remember, we had come from somewhere that if you don't put pegs in place and allow people form unions and so on, especially the security services. But now, if we look at it, can we say the security service can now form a union that would seek to the welfare of their members and so on? So I believe it's undergoing review. Eminent people are on it. Organized labor, you are part. The employers are part, the government is part, a consultant is leading the process, lawyers are there, Attorney General will look at it, it will come to Parliament for us to look at it. So be sure that we are taking into consideration how the world of work has metamorphosed and where we are now and the reality. So this is only an information I thought I should let you know, that except that it's slow, and I am sure that lawmaking process we should also take time so that we don't rush and hit some rock. Thank
Okay,
you.
so we have the Deputy General Secretary NPP here. So
I'm Antoinette Tibudaku. I'm the Deputy General Secretary for the NPP. My Lord, thank you very much. That was an amazing delivery. I think I agree with Saweku Bebe that listening to you is always exciting. That depth of knowledge that you share is always amazing. I'd like to make a comment on the involvement of civil and public servants in politics, because I'm more like a public servant because I'm a university lecturer, but I have to take a leave to be able to engage in politics. For me, I think that as a country that has gone through over 30 years, 3 decades of successful democracy, we are a beacon of hope in Africa. And how have we arrived at this? It hasn't been easy, obviously. Everyone knows how the journey has been. But I fear most that what we risk doing is allowing a lot of public and civil servants to go away with experience, knowledge, which is so important for us to even move to the next stage, because they are not allowed to involve themselves in politics. Our political era today, or the political space today, is characterized by you have to have strong financial grounds to be able to go into parliament. So if you don't have that, or you don't have the courage and the tenacity to survive the electoral process, does it mean you can't contribute to policy making and to development in your country? So if you are not appointed, or if you don't go to parliament, or you don't have the chance to join the executive, it means you can't contribute. That is where my fear is. That if we don't take care, we grow a generation that only thinks that your ability to contribute has to be because you have money, you have resources, you have tenacity, you have the know-how, and then you can enter into the political space. And that is why I strongly believe that if that constitutional provision can be amended, but in quotes, and put into clauses so that at the same time we protect the civil servant who doesn't belong to the opposition party, but at least can make their contribution in a safe environment for the development of our nation. Otherwise, we'll get to a stage where we have rare public and civil servants who go above 60, 65, they retire, and what do? They go away with all the knowledge and would have lost a lot of experience and knowledge. So I believe that for the sake of experience, knowledge, resources, capacity building, and handing over what they have learned, because to have gone through 3 or 4 different governments and still be in the civil service, believe me, you are an icon, you are a hope, you possess a lot of knowledge that we still need to keep developing our country. So if there's a way of making some space for people like that to partake in politics, because that is what controls policy making today, I think we should think about it. Thank you very much.
thank you. Okay, so we take our final comments from Justice. I don't know if you have noted certain things now you want to touch on briefly.
Thank you very much. I think all the comments have been made in good faith, and they have addressed the core issues we have. The Constitution we have now, there's consensus that it needs to be amended. How do we do the amendment? Should it be a holistic revision of the entire Constitution, or article by article? Those are the issues I believe that the civil society organizations and the political parties should judge and come out with a formula to deal with it. Because clearly there is a need to revise the Constitution 3 decades down the line. Now, one of the people I respect most touched on the numbers in the Supreme Court. And he also made mention of the fact that in the U.S. Supreme Court, they deal with about only 5% of the cases that come before them. That is true. But then in Ghana, we are supposed to deal with all the cases that come before us. And when we went to the U.S. Supreme Court, I'll just give you one example. They asked us the numbers of judges we have on the court. At that time, we were 13, so we told them 13, and they were laughing. And they said, oh, small country, we have 13. The big country, America, they have 9. So I gave them this example, that in Ghana, most of us are appointed from Court of Appeal, High Court, and so when the cases come, and the registers go through, say, oh, Jones Doche, you have dealt with this case when you were in the High Court, or even when you were a lawyer or at the Court of Appeal, so you cannot deal with this case. Then we come from communities. I won't mention the community by name, but there was a community that had a chieftaincy case which traveled from the High Court to the Supreme Court. And at the material time, in 2008, when the matter came before the Supreme Court, there were 4 judges from that small community in the Supreme Court. So none of them could sit on the case. Because if you sit on the case and you give judgment against your Omahini, are you going back to face him? So we gave this example, and they said they also have it in America. But in America, what they do is, in conference, before we sit, we hold conferences. You just have to tell the president of the panel, which in all cases is the Chief Justice of the U.S., that, oh, I come from Kentucky, and this matter comes from Kentucky. It affects me. I know the people. So he will ask you, when the case comes, in open court, say it to the hearing of lawyers on both sides. And that's the end of the matter. For example, he gave us a very good example that a judge, when he was in private practice as a lawyer, he was the lawyer for Barclays Bank. And he was also a shareholder of Barclays Bank. Being in the court, a matter of Barclays Bank came. And it was huge damages if Barclays should lose the case. So he told them in conference, CTHE says, you know the practice. You go to court and you announce it, that these were your positions when you were in practice. You also have shares in Barclays Bank. He did. And the lawyer said, he can go ahead. Both lawyers on the other side said, you can go ahead. And he constituted the panel, and they gave judgment against Barclays. You know, so, you see, these are some of the issues we have in the court, and the Constitution allows all appeals from any matter to the Supreme Court. But as he rightly said, only 5% of the U.S. Supreme Court appeals are held by the Supreme Court. And therefore, we toil day and night to determine the cases as they come. If they can have the U.S. example here, we can have a fewer number of justices who can deal with the matter. Otherwise, we'll have to keep the numbers rising very high. Thank you very much.
Thank you, too. So if you have joined us in your homes, you are watching Clock TV at the 6th Nathananang Quao Annual Lecture and Excellence Awards 2023, and the theme is Constitutionality of the Presidential Office Act 1993, the Act 463. We'll be zooming into the award segment of the program, but we have Clocksack Band in the house. So Clocksack Band, you take over as we zoom in.
We are all involved, building our motherland. Arise, can you for your country? The nation demands your devotion. Let us all unite to uphold it and make us great and strong. Arise, can you for your country? The nation demands your devotion. Let us all unite to uphold her and make her great and strong. Sing with me now. We are all involved. We are all involved. We are all involved in building our motherland. We are all involved. We are all involved. We are all involved in building our motherland. Come on. We are all involved in building our motherland. Oh yeah. We are all involved. Oh yeah. Oh la 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 la. Oh yeah. Let us all unite to uphold her and make us great and strong. Arise, Ghana youth, for your country. The nation demands your devotion. Let us all unite to uphold her and make her great and strong. We are all involved. We are all involved. We are all involved in building our motherland.
Okay, thank you, Glosak Band. We have Wendy Danwa here. A round of applause for Wendy to help us.
Citation in honor of Mr. John N.O. Ankara. This is to honor you, Mr. John N.O. Ankara, for your exceptional contributions and unwavering commitment to excellence in civil service and unionism spanning over 4 decades. In recognition of your outstanding dedication in advocacy for workers' rights and fostering constructive dialogue between labor and management, we bestow this award of excellence upon you. Throughout your distinguished career, you have demonstrated unparalleled leadership, strategic vision, and a profound understanding of the issues that impact the workers and their families. Your ability to strategically convince government to yield to workers' demand through the use of a strategy popularly referred to in labor negotiations as suffocating tactics is worthy of mention. Indeed, you are a champion in this style of negotiation. Also, your baritone voice would normally back the suffocating tactics, which secures the negotiation in our favor. Your relentless pursuit of fair labor practices, improved working conditions, and pursuit for equitable compensation has had a transformative impact on the lives of countless workers across the country. As a model of integrity and ethical conduct, you have consistently upheld the values of professionalism, transparency, and inclusiveness, earning the admiration and respect of colleagues and adversaries alike. Your remarkable achievements and significant contributions have not only enriched the labor movement, but have also served as an inspiration to aspiring unionists and advocates of workers' rights. In appreciation of your service with integrity and professionalism towards the cause of the civil service and labor, on the 6th Nathananang Quao Award ceremony, CLOSA confers on you the Nathananang Quao Award for Excellence 2023.
So to help do the presentation, we invite Honorable Repu to join us on stage to do the presentation. A round of applause for Honorable Repu to join us do the presentation. Oh, a round of applause for Honorable Repu as he does the presentation for us.
So that is tears of joy. So tears of joy. Oh, you can do better than that. Come, Closak Band, take it. Let's go once more. Let's do it once more. Wow. Tears of joy. Thank you so much, Honorable Reku Brobe. So don't worry, after the program, we are going to take more pictures. Wendy is still here with the second award. So Wendy.
Citation in honor of Mr. Daniel Amamo. This is to honor you, Mr. Daniel Amamo, a teacher, a civil servant, and a unionist, for your exceptional contributions and unwavering commitment to excellence in the field of unionism. Having served in various capacities in the Prices and Income Board for 3 decades, and with CLOSAG as Director of Administrations for over a decade, is no mean achievement. In recognition of your outstanding dedication and contribution in salary administrations in the public sector, advocacy for workers' rights, fostering constructive dialogue between labor and management, and tirelessly championing the interests of union members, we bestow this award of excellence upon you. Indeed, your knowledge and understanding of staff grading, placements, and salary structures in the civil service has contributed positively during negotiations and the general operations of CLOSAG. Also, your high retentive memory of the laws, rules, and regulations relating to labor issues is an envy to many. Your ability to analyze the mathematical and statistical implications of issues during negotiations to justify our demands is highly commendable. As a model of integrity and ethical conduct, you have consistently upheld the values of professionalism, transparency, and inclusiveness, earning the admiration and respect of colleagues and adversaries alike. These remarkable achievements and significant contributions have not only enriched the labor movement, but have also served as an inspiration to aspiring unionists and advocates of workers' rights. In appreciation of your service with integrity and professionalism towards the cause of the civil service and labor, on this 6th ANANG Quao Awards 2023, CLOSAG confers on you the Nathananang Quao Awards for Excellence 2023.
So to help do this presentation, we invite Justice Roche to do the presentation for us. A round of applause for Justice Roche to help us do the presentation. So Justice Roche Malone. Okay. Mr. Daniel Mamo. Okay, so we'll take some few words from the awardees. So take a pic. Okay. So please, shall we all be seated as we take some few words from them?
To CLOSAG, I say thank you. And to all who contributed to my nomination and the presentation in such a forum, I will remain grateful. I am grateful because this is really a pleasant surprise. I don't want to go further, but what touches my heart most is that
most of us go by the dictum of Antonio in Julius Caesar, where he said, the evil that men do, we don't forget, lives after them. But the good is what? Buried with the bones. Clocksack has shown that we have moved into a different era, and that the good has not been interred with the bones. And that's what touches me. Thank you very much. Thank you.
Thank you. Okay. Thank you so much. At this juncture, I'm going to invite Mrs. Beatrice Bampo Ado to join me with a vote of thanks. We want to say a very big thank you to Clock TV. Those of you here, when you get home, please kindly watch Clock TV. We have a lot of good content for you, so make sure you are watching Clock TV. As well, we have Clock Sack Band, the band of the moment. If you are wedding, engagement, any event, tomorrow Friday, I'll meet them at Jam Rock, and trust me, they are very good. A round of applause for our band here, Clock Sack Band.
The Justice of the Supreme Court of Ghana and the Gambia, Justice Mawulom Duche, the Honorable Deputy Minister for Employment and Labor Relations, the Head of Civil Service, CLOGZAG National Executives present, executives of other labor unions present, chief directors, directors and deputies, CLOGZAG members, media friends, CLOGZAG band, viewers on Clock TV, and all protocols observed. Today, we have had the privilege of experiencing an intellectual, enriching, and inspiring St. Nathananang Quao Lecture and Awards on behalf of the Executive Secretary of CLOGZAG and the organizing body of the St. Nathananang Quao Excellence Lecture and Awards. I extend our heartfelt gratitude to each and every one of you for being part of this exceptional event. Our deepest appreciation goes to our distinguished guest of honor, Justice Victor Mawulom Duche. Thank you very much, Akpe. You agree with me that his presence added immense value to this gathering. His profound insight and lifetime dedication to justice have undoubtedly left an indelible mark on all of us. We extend our sincere gratitude to the esteemed distinguished dignitaries in our midst, whose valuable presence and participation elevated the prestige of this event. A special thank you to all media friends for sharing their perspectives on crucial matters shaping our legal landscape today. Our contribution and your contribution has stimulated important dialogues and will continue to resonate with us long after this event. To our esteemed audience, thank you for your participation. Thank you very much. Your enthusiasm and involvement have added depth of this discussion, making this event a success. In closing, let us carry the wisdom and knowledge gained today forward into our lives and work, aspiring to embody the principles of justice and fairness that were eloquently discussed. We look forward to continue engagement in future events. Thank you once again and have a wonderful day. Thank you.
Thank you. At this time, we invite Pastor Bayo to join us. And watch out for Pastor Bayo on Clock TV, Wings of the Morning, very soon. You start watching him. So thank you so much.
May I crave indulgence? So we pray. Shall we please rise as we pray? Our Father, we want to thank you for the success of today's program. We declare right now that the Lord bless you and keep you, The Lord cause his face to shine upon you and be gracious upon you. The Lord lift up his countenance upon you and give you peace. The rest of the day is blessed in Jesus' mighty name. Amen. Amen. Let's share the goodness together. Grace of our Lord Jesus.
Sweet fellowship of the Holy Spirit be with us now and forevermore. Okay, so we are going to have a group photograph here in a particular order. So the media, please kindly stay. The media, don't move. Just stay at where you are. We'll get to you.
There's a new world somewhere they call the promised land, and I'll be there someday.